Let people in from the waiting room at the moment. We will get going in just a few minutes. Thanks so much for joining us today. Now, so we will get started. I'm Taryn. I'm here to monitor the chat and to make sure that everything runs smoothly in case there's any tech issues. Um, Please, throughout the presentation, feel free to put any questions in the chat. We will answer them all at the end and possibly throughout. If we run out of time towards the end to answer all the questions, don't worry. We're going to send out an email with all of the questions that we answered and those that we didn't cover following the presentation. So everyone will get all the info that they need. And if you have to leave for any reason or aren't able to stay throughout the entire presentation, no worries. We're also going to send out the slides and a recording at the end. So I'm going to pass it over to Cameron now to get started.
All right. Hi, everyone. Thanks for joining today. Hopefully you are here for the Let's Make a Deal webinar. If you're not, you may have clicked on the wrong link and might need to attend a meeting elsewhere. Um, as Taryn noted, please feel free to put any questions you have in the chat. I will try to answer them as we go through the presentation, and anything I don't get to, we will answer at the Q&A at the end. It's always great to know who our audience is. So if you can put in the chat where you're from, what your occupation is, what your industry is, feel free to let us know, and maybe I can tailor some examples to you and your particular circumstances as we move through. As Taryn noted, my name is Cameron. I've been practicing at KSW for the last 6 months, but have been practicing in the area of M&A and other commercial transactions since I graduated from law school in 2020. And we're hoping to just get you a high level understanding of how to go through the process of buying or selling a business, if that's something that might be on your mind. So buying or selling a business is a more than just a legal endeavor. It's a combination of a business strategy, a finance, and an operations endeavor, and it's certainly not a simple process. Success really hinges on trying to align all of those different practice areas. And in order to really be successful, you need the correct advisors and input in all areas. Today, we're going to cover the sort of life cycle of purchase or sale transaction from a couple different perspectives, including a share purchase and an asset purchase. You'll find that due diligence is a theme that we keep coming back to throughout the process, as it plays a role in all aspects of an M&A transaction. During the presentation, I'll try to use some practical examples that show you how sort of each phase of an M&A transaction works in practice, and some things to consider if you're trying to implement what you've learned here today. The goal here is to sort of give you a high level mental model of the deal process, starting from the preparing for a M&A purchase or sale, the different transaction structures that are available to you in the process, considerations that play a role in due diligence, and of course, give you an idea of the professionals you might retain to help you in the various parts of these transactions, because obviously no one can do these things alone. As I practice, and KSW primarily practices in British Columbia, this presentation is intended to be focused on the law in BC. The transaction process is fairly standard throughout other jurisdictions, particularly within Canada, but practices do vary, and obviously each jurisdiction across the provinces and outside of Canada will have different applicable laws and standard practices. So for the purposes of our presentation today, I have broken the deal process into effectively 3 phases. This is certainly not a hard and fast rule. It's just a way of managing the process. The first phase is the preparation negotiation phase. The second is the transaction phase, where binding agreements are completed. And then the third is actually closing the deal and what happens after closing, because no closing is not the end. So moving on to a timeline here. Buying or selling a business is not a straightforward process. It takes some time to do correctly. At the outset of a transaction, you're going to want to get your advisory team together. That would include your accountant, lawyer, As a seller, you might want to engage a what's called an M&A advisor, which can range from business brokers who serve a similar function to real estate agents, all the way up to in very large deals, investment banks who will come in prior to the transaction, do a thorough review of your business, help you to optimize contracts and your business's financial and legal position to try to help attain the highest purchase price possible. And there are M&A advisors who work with all sizes of business and offer different scopes of assistance. Done properly, an M&A transaction of business purchase or sale can take anywhere from a few months to a year, depending on the complexity of your business, the um, level of existing documentation and organization within the business prior to preparing for the transaction, um, and other factors such as size. Um, the negotiation phase, if you will, the preparation negotiation phase, can take anywhere from a few weeks to 3 or 4 months, sometimes longer if business is particularly large. And during that phase, you'll of course engage your team, your M&A advisors. You'll want to get an NDA or a confidentiality agreement put together for buyers who will want to conduct due diligence on your business. And once you've identified a buyer, you'll negotiate a letter of intent, which deals with um, key terms of a transaction that the buyer hopes to complete with the seller. You'll see on this slide on the bottom left corner there, tax planning off to the earlier phase. Um, an organized seller will want to engage their tax professional at least 2 years in advance of planning the sale of their business. Uh, Tax lawyers and specialist tax accountants um, will have advice as to opportunities to restructure your business in a manner that will allow sale to be more tax efficient, put less money in the taxman's pocket and more money in your pocket. Um, but some of those reorganizations will require a holding period, usually around 2 years, before you'll actually receive the benefit of the reorganization and tax planning. So if you are considering a sale, not to worry. Plenty of people go through the sale process without that 2 year lead time, but it's certainly something to consider if you think you might sell in the future but aren't planning to sell immediately. Getting that tax guidance at the outset can be very valuable. The transaction phase is the implementation of the transaction that is framed in the LOI between the buyer and the seller. That might be the transfer of shares of a company from the seller to the buyer, or it might be the company itself selling its assets to the buyers. And those the considerations that go into that are often tax related, but also driven by any number of operational and business needs. Um, the closing and beyond, or closing and post closing phase of a transaction is really where the agreement that has been struck between the buyer and seller are implemented. So the purchase agreement, whether share purchase or an asset purchase, is not the end. It serves as a roadmap to completing the transfer of the business to the buyer. Um, the closing phase is what takes us down that roadmap. It implements the obligations and the transaction that is contemplated and structured by the LOI and the binding purchase agreement. So we'll cover all those points as we move through the slides in the next half hour or so here. So, phase one, as we discussed, the negotiation preparation phase. Um, Mergers and acquisitions advisors has effectively two meanings. Broadly, it can refer to the entire team of advisors that you, as a buyer or seller, might engage in the context of a purchase and sale transaction. That would refer to your accountant, your lawyer, your M&A advisor, whether it's a business broker or scaling up to advisors or an investment bank. Um, and as well as any specialists you might engage in the due diligence process. You might need a real estate appraisal or an appraisal of equipment. You might engage a business valuator for the purposes of confirming your estimate of what the business should be valued at, along with any other number of specialists as determined by the needs of your due diligence. The narrower meaning, which is less known to people, is a mergers and acquisitions advisor is essentially a company or a person who helps a seller prepare their business to be sold. Um, these individuals and companies often will provide assistance in estimating the value of the company based on the financials and their operations. They may help a seller organize their documentation in a manner that makes it easier to disclose to potential buyers during due diligence. And they may consult on matters related to maximizing the value of the business, making sure that all of your employees have contracts in place, that all of your permits are up to date, and all of your contracts are in good standing. And so that process can take a significant amount of time, especially for larger businesses, as your M&A advisor can, if engaged to do so, really help you structure the business to maximize the value you get out of its sale. Um, they also help with smoothing the process as you go through trying to interview buyers and negotiate a deal. These transactions are not for the faint of heart. They can be very intense and very stressful. So having an M&A advisor in that narrow sense to help with negotiations and just managing the whole process on your behalf can certainly take a burden off of you, particularly as you will want to continue to focus on running your business or need to continue to focus on running your business while you're preparing it for sale. Um, on the buy side, the buyer's side, it's less frequent that they have an M&A specific advisor in a narrow sense, but of course, buyers will also engage their lawyer, their accountant, and other specialists as necessary to help them go through the due diligence process and make sure the business they're buying is actually what they believe it to be. Um, Confidentiality agreements. These are usually the first agreement that is signed between a buyer and a seller. Um, Often these agreements are prepared by the buyer or the seller, sometimes their M&A advisor. Ultimately, you should engage as a seller your lawyer to prepare the confidentiality agreement or NDA, as they are fairly technical agreements, and they need to be. Uh, it's important, given the sensitivity of commercial business information, that they be binding on the correct parties and um, effective at giving you remedies if there is a breach of confidentiality and your sensitive personal or corporate information is disclosed. So, what should be contained in a confidentiality agreement? Well, you'll want to make sure you have the proper parties set out therein. If a buyer is purchasing your business through a company, that company should be bound, as should its directors, officers, and anyone else who is uh, intending to or intended to receive your confidential information. Um, NDAs and confidentiality agreements also aren't specifically limited to prohibiting disclosure of confidential information. You would also want to generally see a provision in there that says the receiving party of the confidential information will not use that information for any purpose other than evaluating the transaction that they are considering with the seller. Um, this protects the seller in that it prohibits the buyer who may be a competitor from using the seller's information to their advantage if the deal weren't to proceed and they remained competitors going forward. There's also privacy legislation that applies to the disclosure of employees' personal information and business information. So the confidentiality agreement should consider that, as well as in the case of competitors, you'll want to include language that prohibits a potential buyer from soliciting the services of employees of the business that's being sold in order to benefit the buyer's business in the event that a transaction isn't consummated and doesn't proceed. So there's a lot going on in these agreements, and they um, need to be prepared in a manner that is both practical and comprehensive enough to ensure the seller's information is protected. In some cases, confidentiality agreements will be mutual, where the buyer and the seller may be disclosing um, confidential information to each other instead of one-way disclosure from the seller. Such cases are usually when the part of the purchase compensation for the target business is shares or an interest in the buyer's company rather than cash. And we'll discuss that in a little bit here. Um, and on to our next slide. The letter of intent is the principal document that really establishes the business terms, the key business terms and structure of a M&A transaction. So typically at this point, the parties will have entered into a non-disclosure agreement, and basic information about the seller's business, usually financial, will have been disclosed. Financial statements will have been disclosed to uh, give the buyer an idea of what it is they're purchasing and what the value might be. Um, and at that point, the buyer will usually rely on their lawyer to sell or to prepare and propose a letter of intent that sets out the proposed transaction. Um, the letter of intent typically contains the parties to the agreement, outlines who will be the buyer, whether it is the purchaser individually or if they'll be purchasing through a corporate entity or other legal structure. Um, it sets out the intended structure as to whether there will be a share sale where the seller is the shareholders and they transfer the shares of their company that operates their business to the buyer, or if the buyer buys assets directly from the seller's company. This decision is often driven by uh, primarily tax implications, but also potential liabilities and the complexity of these target businesses' corporate structure can play a role. At a high level, the sale of shares tends to be a little bit more tax favorable to the sellers, as there are capital gains exemptions that may be available to them under tax law. Whereas the purchase of assets can be a little bit more favorable to buyers, all other things being equal, in that they can get a higher cost base for future depreciation and tax benefits after the sale, as well as avoid inheriting any liabilities associated with the seller company, which you would inherit if you bought the shares of the company and took the whole kit and caboodle there. Basic terms that you'll see in LOIs are, of course, the price, some information about the state the company is required to be in at closing, um, and then any particular deal specific terms that that might apply in a case by case basis. Things like if there is a employee who needs to be terminated prior to the transaction completing, or perhaps key employees that need to be retained in the long run. Um, that type of stuff will be set out in there. Any conditions that must be fulfilled prior to the transaction, such as the buyer's ability to obtain financing on reasonable terms, the buyer's conduct of due diligence to make sure the company is in a reasonable state from an operations and liabilities perspective, um, and any other covenants or agreements that are really core to the deal that would be potential deal breakers are typically recorded in the letter of intent. Letters of intent are generally non-binding, or at least the substantive deal terms are considered non-binding, so that they essentially form a basis from which the parties can work, but can be altered depending on the results of the party's due diligence, the buyer's due diligence, and any changes in the business in the process of completing due diligence. There are generally some binding terms in the LOI. Generally, this includes a restatement of the confidentiality obligations with respect to information disclosed in due diligence, perhaps an exclusivity period where once the LOI is signed, the seller agrees not to engage in negotiations with anyone but the buyer for a defined period of time. And other deal specific matters, but generally you'll find those two terms are included in the letter of intent. The key to a letter of intent is really clarity, as it forms the basis of the negotiations of the substantive terms. You really want to ensure that the parties are on the same page going into the negotiation of their purchase agreement and binding legal agreements. I will note for fulsomeness that share purchases and asset purchases aren't the only forms of transactions that can occur in an M&A process. The law, particularly the Business Corporations Act, provides for some statutory um, uh, mechanisms through which companies can be amalgamated, effectively taking two companies and causing them to combine into a single legal entity, as well as what's called a plan of arrangement, which is a court monitored process for um, uh, carrying out a transaction. These are typically used in much larger transactions, and you don't frequently see them outside of a more public company type transaction. One other key aspect of the decision that goes into determining whether shares are sold or it's an asset sale is the ability to assign assets. So when an asset sale is agreed to, the business is agreeing to sell the things it owns to the buyer. There are limits often when you've entered into contracts, for example, leases, on the ability to carry out an assignment. Um, and so an asset sale will require that the business that's being sold get consent from third parties if its agreements with third parties require it to do so. This can lead to a more cumbersome set of closing documents as you're reliant on third parties to sign off on the transfer of certain assets and so on. Whereas with a share sale, the actual transfer process tends to be a little bit more streamlined because all you're doing is transferring shares, which effectively transfers the entire company and everything owned by it without the need for consent to an assignment of the assets of the company. Um, Now, once you've negotiated your letter of intent, you end up going into the transaction phase. Essentially, this is the period part of the transaction where the buyer will have now agreed to confidentiality terms, and the seller, while relying on their M&A advisors, will disclose its confidential information for review by the buyer and their advisors. This Once that review is commenced and ongoing, the uh, buyer will have its legal counsel prepare a draft of the um, purchase agreement, which will ultimately form the basis of the binding terms of the transaction. Um, if on occasion, if due diligence reveals an issue, for example, as I touched on previously, assets that can't be assigned from the target company to a buyer, uh, the parties might agree to change the proposed structure of the transaction from an asset sale to a share sale, or vice versa, if there is discovery of perhaps an undisclosed liability related to the target company that can't be adequately dealt with. The buyer may no longer wish to purchase the company itself via acquisition of its shares, and instead buy the relevant assets used in the business. As I noted previously, the choice has significant tax consequences as well as consequences with respect to the documentation and the mechanics of closing the transaction at the end. Once the purchase agreement has been signed and the transaction is ready to proceed. Um, the Statutory alternatives are also available, the amalgamation process and the plan of arrangement, but I won't cover them in any detail here. Now, I've used, oh, having some trouble with, there we go, next slide. I have used the term due diligence quite a number of times since we started the webinar here. Due diligence is effectively the process through which the buyer becomes familiar with the business it's buying and makes sure that it is as the seller represented the business to be. And so there's um, numerous aspects to due diligence involving various professionals. Here on the slide, I've broken it into sort of four key areas, being financial, legal, tax, and operational. Um, that's by no means a standard practice. This is just how I frame it for myself. Other professionals may have different approaches, um, and often you'll find that various aspects of a business, a target business, have to be reviewed from different perspectives in due diligence. For example, you might have an aspect of the business that has to be reviewed by legal professionals from a legal perspective, but also by other professionals from an operational perspective. A good example might be real estate. Your lawyers might be looking into legal issues regarding ownership and rights with respect to a property, while you may also retain a real estate appraiser to confirm that the value of the real estate is what you approximated it to be. And perhaps real estate inspectors or environmental engineers and advisors to confirm that there are no problems or environmental hazardous liabilities associated with um, the real estate. Um, with respect to each heading, at a high level, financial due diligence is generally involves the buyer's accountants reviewing the financial statements of the company to come to a determination as to the financial health of the company, as well as more detailed due diligence regarding the actual accounting that has been done by the company to make sure its ledgers and transaction records are accurate and properly recorded in accordance with accounting principles. Um, Legal due diligence is, of course, conducted by your lawyer and their team. This would include sort of two separate categories of due diligence. One being review of all of the company's documents, legal documents, to make sure that they are binding and don't contain unusual or onerous terms, or as discussed previously, require that third party consent to the transaction be attained. And the second aspect of legal due diligence would be that related to um, compliance with laws that apply to the company. For example, if permits or licenses are required to operate in the industry that the company is in, ensuring that those have been acquired and that the company is compliant with those permits and licenses. Um, there's also, of course, statutory requirements with respect to um, the corporate documentation of a company and its records, records related to shareholder meetings, the list of shareholders held by the company, um, directors' meetings, so on and so forth. And so that's legal due diligence really follows those two streams, focusing on compliance with laws, as well as ensuring that the business's documentation is legally binding and that the completion of the purchase and sale transaction complies with any requirements that are found in its documentation, whether that be leases, employment agreements, licenses, and permits, um, and any other documentation that the business may have or have entered into in the course of its operations. Tax due diligence is often a team effort between the buyer's tax lawyer and accountants, and that really focuses on reviewing the financial information and filings made with the CRA to ensure compliance with and full payment of all tax liabilities by the target business throughout its operations. Um, One could also put in this category the structuring of the deal and the investigation of potential deal structures that will ultimately be optimal for both the buyer and the seller from a tax perspective. Finally, we have the sort of broad category of operational due diligence. This kind of due diligence is typically done by the buyer's team or their business consultants. Um, and this is a comprehensive review of the target company's operations. And so that might be meeting with and understanding the management structure and all of the employees of the business. It might include um, uh, conducting investigations and inspections of the target business's various premises, whether that be industrial premises or office premises, um, reviewing the business's non-legal documentation, or I guess less legal documentation, including standard operating practices, privacy or other internal policies, um, uh, again, employment agreements and obligations to contractors or service providers and other third parties. Um, really, with the goal of being able to step into the shoes of the seller and understand what the business is currently doing, how it's going to operate moving forward, and what its obligations are to avoid a bumpy transition process after closing. Um, Now, due diligence, as I think I mentioned before, typically runs parallel to the preparation of the purchase and sale agreement, whether that be an asset sale, purchase and sale agreement, or a share purchase and sale agreement. And the terms of the purchase and sale agreement are generally informed by um, the the results of the due diligence. As we've listed here, there are sort of some core aspects to a purchase and sale agreement, including, again, as noted with the NDA and the LOI, making sure we have the correct parties to the agreement, so that the obligations therein are binding on the correct parties, because a contract cannot bind someone who is not a party to it. So the obligations can only be enforced against the parties, and therefore the correct parties need to be made party to the agreement in one way or another. Then you'll also generally find the price and payment terms, a comprehensive set of what are called representations and warranties. At a high level, these are statements made by the seller as to the status of the business, um, and inaccurate statements form a basis for breach of contract, for which the buyer can generally seek compensation um, after the closing if they've suffered a loss due to the inaccuracy of the statements. You also have covenants, which are promises to do or refrain from doing something while subject to the terms of the purchase agreement. Conditions, which are sets of circumstances that must be either fulfilled or waived by the person for whom they are to benefit, in order for the purchase agreement to bind the parties and require them to complete the transaction. And then the purchase agreement also generally includes indemnities, which govern the mechanism through which a party may recover losses from the other party, whether buyer or seller, due to breach of any of the other terms in the purchase agreement, as well as what needs to be delivered on closing in order to complete the transaction. Um, the purchase agreement, whether an asset purchase agreement or a share purchase agreement, is what I would call a roadmap. It sets out all of the obligations for each party that are necessary to be fulfilled in order to complete the transaction in the manner the parties intend. Um, and so the purchase agreement, as I mentioned, certainly is not the end of the transaction. It's definitely a big milestone, and parties should be very happy once they've settled the terms and signed off on a purchase agreement. But there's much work to be done despite having reached that point. Payment terms can vary quite significantly across different deal structures. I've set out here some of the more common variations. Often, the purchase price will be paid entirely in cash on closing. In order to do so, buyers will, in some instances, have to rely on financing, borrowing money from a bank, and that is not covered in this transaction, but also is a process that they run concurrently with their due diligence in order to ensure they have the cash available to them to make the payments on closing. If that's not an option, sometimes the vendor will allow the buyer to pay in installments over a period of time, which is called vendor financing. Um, and typically, the vendor will take some form of security to ensure that they get paid those deferred payments after closing. Um, Payments without cash often include the issue of shares in a company owned by the buyer or a related party as consideration for transferring the assets or the shares of the target business to the buyer. These types of transactions are very complex because the seller will have to do mutual due diligence on the company in which they're receiving shares as compensation to ensure that that company is as valuable as the buyer represents it to be. Um, Earnout provisions are a mechanism for bridging a difference in valuation between the buyer and the seller. The seller may say their company is performing well and growing, and the purchase price should be higher than what the buyer is proposing, and the buyer may disagree. In such instances, purchase agreements may contain terms that say if certain milestones are met during a period of time after post-closing, additional payments will be made by the buyer to the seller to compensate for that good performance and reaching those milestones. Um, Holdbacks are a mechanism of security for the buyer. Often, a portion of the purchase price will be held back by the buyer for a period of time after closing, so that if they discover the seller has made an inaccurate representation or hasn't fully complied with a covenant or a promise required of them by the purchase agreement, they can deduct their losses that they incurred as a result of that failure from the holdback before the balance of the holdback is released to the seller. Um, Holdback terms vary significantly across deals, but usually they're held for the same amount of time as the representations and warranties remain in effect in the purchase agreement. There's also security mechanisms for the seller if they have accepted a vendor financing situation. This includes taking a security interest in assets of the buyer or in the target company itself, against which the effectively these security agreements would allow the seller to, if they remain unpaid, seize the assets and sell them to recover what they're entitled to. Mortgages are also a mechanism that can be used. In effect, if the target company or the buyer owns land in exchange for the seller permitting them to defer payment, the buyer or the seller will register a mortgage over the land owned by the buyer or the target company, which would allow them to collect against the equity in that property in order to protect themselves if the buyer fails to make the post-closing payments as required by the purchase agreement. Um, Representations and warranties. So as I mentioned, representations and warranties are essentially a set of promises um, that the seller, or a set of uh, statements that the seller makes to the buyer about the state of the business. Some simple ones are things like the business is not being sued, and is not in litigation. The business is compliant with all of its agreements. The business has all of the permits and licenses required to operate its business, and all of those permits and licenses are in good standing. Um, these statements, especially on larger transactions, can be extensive and generally cover every aspect of the business in some form or fashion to provide assurances to the buyer that um, the there's no hidden liabilities or oversights by the seller in selling the business, and to ensure the buyer is getting what they expected to get and has recourse if they don't. Um, generally, the representation and warranties only remain in effect for a limited period of time after the closing. Um, the time varies by jurisdiction and the negotiating leverage of the parties, but often it's between 1 and 2 years. And any breach of representation or warranty has to be brought forward by the buyer within that time frame, or they lose the ability to collect from the seller um, on that breach. Um, I will frequently go through these in detail with the client, as these are really the basis on which the buyer can claw back value it paid, and it's important for the seller to ensure that the representations that are made are accurate, and if the representations in the agreement are not accurate, any exceptions or inaccuracies are disclosed to the seller as part of the disclosure schedules, which are schedules that list exceptions and are attached to the purchase agreement and form part thereof. So to go back to my previous example, a representation may be that the company or the business is not engaged in any litigation, and if that's not the case, then any litigation that does exist would be disclosed in the schedules. And such disclosure generally alleviates any breach of contract liability for the seller, but also makes the buyer aware of such issues, and make sure that those are factored into um, the deal terms, the business terms, the purchase price, etc. Of the deal. Um, Moving on. Sorry, my throat's getting a bit dry here. Conditions. Conditions are the obligations, or uh, well, effectively conditions that must be met in order for the deal to become binding. Um, they're generally framed in a couple of different ways. There are objective conditions, which are conditions that are outside the control of the parties. For example, in a heavily regulated industry, a government approval might be necessary in order for the transaction to proceed. Um, and of course, the parties will agree that it's an objective condition of the deal that if they cannot get um, the uh, requisite approval, they won't be bound to proceed. Subjective conditions are generally conditions that are subject to some discretion of one party or the other. A due diligence condition, one that says the buyer's obligation to proceed with the transaction is subject to their to satisfactory due diligence. Um, and financing conditions, which are one conditions you often see in real estate transactions as well, subject to the buyer obtaining financing on a terms reasonable to the buyer, are subjective conditions. They give one party some discretion as to whether or not the condition is deemed to be fulfilled. Um, any number of conditions can apply depending on the structure and deal specifics. I do note that as a general matter of law in Canada and in BC, we have a duty of good faith and honest performance in the performance of contractual relations. This essentially means that if you are a party to a contract, you cannot intentionally lie or mislead to the other party about your performance of the contract. That would be effectively a deemed term you would be in breach of if you did so, and also an obligation to exercise discretion granted to you reasonably and in good faith. And so the subjective conditions, such as due diligence or financing, um, cannot be arbitrarily used to avoid closing a deal for reasons unrelated to the buyer's ability to actually obtain financing, or um, uh, in the case of due diligence, if there's nothing that would actually cause them harm, they just wish to not proceed with the deal. Uh, the seller may have an argument that they're acting unreasonably if they fail to confirm the fulfillment of the due diligence condition. Indemnities. So indemnities are the provisions where the parties agree to cover each other's losses, costs, expenses in the event that a provision of the purchase agreement is breached, and that could be in the form of not fulfilling a covenant. Um, it could be in the form of the buyer or the seller making a representation or warranty that is false, or any other number of um, breaches of any obligations imposed on either the buyer or the seller. Um, Generally, as the slide shows, buyers want broad indemnities that will cover all sorts of losses, and hopefully to an unlimited amount. Sellers, on the other hand, want to make sure that their liability for a breach is contained in some way. Um, and so there's listed there a few ways that sellers mitigate the risk of broad and actually unlimited liability under very broad indemnities. Um, that includes time limits on when the buyer can make a claim under an indemnity, similar to the time limit on representation and warranties. Any claim for an indemnity may be limited to 6 months, a year, 2 years after closing. Um, it can include a cap on the amount that the seller or the buyer will be responsible for in terms of losses. Um, uh, Due to their breach. And these caps essentially serve as a mechanism for pushing some risk onto the buyer or the other party to ensure they're doing their due diligence and not simply skirting through the transaction without doing due diligence on the basis that they'll just sue the other party for anything that doesn't work out for them after the closing. Um, and then thresholds and deductibles are essentially raising the floor on the amount that of loss that has to be suffered before a claim can be brought, and this avoids helps the seller in most cases avoid frivolous claims by the buyer for um, de minimis or non-material breaches of the purchase agreement, stuff that is technical and doesn't give rise to a significant loss. Okay, that forms all of the key aspects of a purchase agreement. So we've now reached the closing and post-closing phase of the webinar. So as we talked about before, the purchase agreement tells the parties what to do. It is a roadmap to effecting the transfer of the business in the manner agreed to. And one aspect of it is the closing documents that are to be delivered by the parties on closing. And that can include documents like transfers of shares signed by the selling shareholders, approvals of directors and shareholders approving that the transaction can go forward. Um, in an asset transaction, it might be an assignment of contracts, assignment of lease. Um, there are also what I call ancillary agreements, and these are closing documents that have to be delivered at the closing, but which don't go directly to the transfer of the business. So, as we discussed before, this might be new agreements with key employees, new employment agreements that adjust the terms of their employment to terms more acceptable to the buyer. Um, that's a key one. Um, it might be what's called a transition services agreement, pursuant to which the seller agrees to provide the training and services to the buyer after the closing for a defined period of time to help them learn more about the business's operations and help them through a smoother transition. Um, the ancillary agreements are very deal specific and depend on what the parties have agreed to in the LOI and as a practical matter in the business transaction. Other deliverables are, of course, when you purchase a company, you're inheriting all of its history, so you need access to all of its historical documents, including, as we've talked about before, tax filings, accounting records, permits and licenses, all of its contracts and agreements with employees, contractors, vendors. All of these things are things you'll need to ensure you know what the company's obligations are going forward. And this is really um, a key role for doing good due diligence, and why due diligence is important is you'll want to have had these things available to you in advance so that you know the obligations of the company going forward, and you know how it operates and how it runs um, before you've actually completed the deal, so that you're not stepping into the seller's shoes and starting operations blind without knowing specifically how everything works. And so it's certainly a reason to conduct your due diligence and do good due diligence early. It really helps with the practical aspect of stepping into and operating a new business. Um, in terms of the content of closing documents, um, these are governed by what's set out in the purchase agreement, and your lawyer should be responsible for ensuring that what you agree to in the closing documents that affect the transaction and the transfer of the business um, are reflected in the closing documents, um, and don't impose any additional obligations that fall outside the scope of the purchase agreement. Um, so once you've closed, as I just sort of touched on, you take possession of the business. Um, However, that's not the end. You now have to operate the business, and that means you need access to all of the business records. You need to know its tax history. You need to know what its obligations are going forward. You need to know what its standard operating procedures are. If it's a manufacturing company, you need to know and understand the process through which it manufactures goods. It's a service providing company. You need to know which individuals and people who are employed by the company provide which services, and what they're good at, and what they don't do. And as I said, the due diligence plays a vital role in getting this understanding prior to the completion of the transaction. There are also some administrative matters that have to be wrapped up after the closing. Often, because businesses are a going concern and they're changing on a day-to-day basis, the purchase price or the business might not quite reflect the financial status on which it was supposed to be bought. And so typically upon or following closing, the buyers and the sellers accountants will do an analysis to complete um, uh, a working capital calculation and a set of closing date financial statements um, that show what the actual state of the business was financially on the closing date. And the purchase price might be adjusted up or down after closing to provide a little bit more cash or a little bit less cash to the seller, depending on whether the financial state of the business was better on closing or worse than was being targeted. And so this is usually a 90 to 120-day process following the closing, after which the buyer will either receive a small refund or have to put up a little bit more cash to bring the amount that it paid into alignment with what the purchase agreement required. Um, of course, following the closing, the buyer may realize that the seller wasn't entirely truthful in their representations and warranties. So they should do a thorough investigation of the business's operations to see if they can identify any areas where the representations and warranties were inaccurate, or any other promises or covenants of the seller weren't fulfilled, so that they can seek compensation from the seller and make a claim for compensation within the timelines required by the purchase agreement. And finally, with respect to tax matters, when you sell the shares of a company, and the individuals who control the company change, there is a deemed year end for tax purposes, and essentially, tax returns have to be completed for the period from the last year end to the date of the sale, what's called a stub year. And after that, the buyer starts a fresh year from the date of the transaction going forward. Um, and so the buyer and the seller's tax professionals have to be retained post closing to ensure that the appropriate stub year filings are made, and that all parties are agreeable, that they're filed in a manner that is reasonable. Anyway, that is the extent of our presentation today. I'm trying to click on the last slide here, but it doesn't seem to want to move for me. So thank you for attending today. I hope you learned something useful and can take something practical from the presentation. And we hope to work with you in the future.
Sending out an email with the recording and the slides after this. If you do find that you have any questions following, feel free to email us, or reply to the email that's going to go out to you. And we'd love to answer those questions for you. So thanks again for joining us, and we hope to see you again soon.